Kim Stanger. I'm the head of the firm's Health Law Group. Welcome to the next in our series of healthcare compliance webinars that we offer to our friends and clients. Today, we're going to be talking about corrective action, credentialing, HCQIA, and the NPDB requirements. We've got a lot to cover today. I'm going to talk about credentialing and privileging standards, corrective action, the process that you go through, and some considerations. We're going to talk about the Healthcare Quality Improvement Act, the National Practitioner Data Bank reporting requirements, peer review privilege, defenses and protections. So we've got a lot to cover. I'm not going to be able to get to all the slides. I think I've got 80 or some odd slides, but I decided to go ahead and provide all those slides to you just in case they're helpful along the way, even if we don't cover everything. Preliminary disclaimer on this. The standards that we're going to talk about, this usually comes up in the context of hospitals. It can apply in other situations too that are participating in the NPDB reports, large physician groups, ASCs, things like that. But I may just by habit default to hospitals. We're going to be moving pretty fast, and as we discuss these items, remember this. I'll focus on the federal standards and kind of the general standards that apply out there. However, each state is different when it comes to the licensure issues for providers, for facilities, and each state may have its own requirements when it comes to things like credentialing. And so make sure that you understand those particular standards that may apply in your case. Particularly, those particular standards, the things we're going to talk about today, may vary depending upon the state, the provider type, whether you're talking about physicians or APPs, accreditation standards that you may have to comply with, which may or may not be consistent, contract requirements, bylaws and your policies, and other factors that may affect this. So make sure that you know and comply with your state laws and other applicable standards when it comes to actually applying the things that we're going to be talking about today. A couple of housekeeping items. If you did not receive copies of the PowerPoints or links to the written materials that I've also provided to you, feel free to contact Lisa and she'll make sure that you get that. The presentation will be recorded like all of our other health law webinars, and it's available on our website should you want to access that again in the future. Because it is going to be recorded, we won't take questions during the program, but if you have questions, feel free to submit them using the chat feature, or you can simply email me and I will do my best to respond offline. All right, with that said, let's get into it. Let's talk about credentialing. Well, a few preliminary comments. Who must be credentialed? Who do you have to credential? In general, you've got to credential all those licensed independent practitioners, those who may order tests or procedures or services, perform services at the hospital, those who can act independently of others. Now, that would be things like certainly your physicians, podiatrists, dentists, APPs, psychologists, therapists, others. Sometimes some of those non-physicians are referred to as limited license practitioners or maybe allied health professionals, but those are the ones that under applicable laws, you generally have to engage in credentialing. Now, for those people who aren't on that list, that doesn't mean that you can't just ignore them, right? They may not go through the regular credentialing process, but people like nurses or techs or those, you still have to make sure that they're competent. If not, then you could be liable as an employer for negligent hiring or simply respondeat superior. So you still need to check on those, but we're really going to be focusing on the credentialing process for those who are independent practitioners at your facility. Well, what does credentialing address? Well, it generally addresses medical staff membership and or clinical privileges, and the two aren't the same. Sometimes they're used interchangeably, but the two are different, at least for purposes of our discussion today. The medical staff membership, for purposes of our discussion, are those professionals who constitute your medical staff, which is the organization of these independent entities that have responsibility for the care and quality at the hospital. They're kind of like the members of the club. They've got responsibilities to oversee the medical staff members, and they have to perform certain functions on behalf of the hospital. Separate and apart from them are those clinical privileges is different. Clinical privileges just means that a particular practitioner has a license in the general use of the word, not a license from the state, but it's got permission in order to perform certain services at a particular hospital. In both of those cases, almost always, The relevant statutes and standards require that the facility's governing board has to determine those who are going to be granted medical staff membership and/or clinical privileges. And it's possible that you could have one or the other. It's possible you could have medical staff membership and not clinical privileges, or alternatively, you might have clinical privileges and not medical staff membership. Now, why do you do proper credentialing? Why is it important? Well, it's to make sure that you got the right people on the medical staff, right? It's important for quality healthcare. It avoids problem practitioners. It facilitates a professional workplace. It's becoming increasingly important to have quality providers given the value-based care initiatives that are out there. And, ultimately it's in the best interest of patient safety, and it prevents liability to others. But in order to avoid that liability, you need to make sure that your credentialing is taking place in an appropriate manner. And when I'm talking about credentialing, I'm really talking about not only the initial assessment of who's going to be allowed privileges or at the facility, but also it involves ongoing professional review, peer review, OPPE, FPPE, those things. The key here is you need to make sure that that's done in the right way. If it's done in the right way, then it leads to quality care and a quality workplace. On the other hand, if you veer off and you don't do it in an appropriate manner, you could be liable to the patient for malpractice or negligent credentialing. You could be liable to the government if you don't do it, because state licensure rules, conditions of participations, accreditation standards generally require you that you engage in appropriate credentialing. But on the other hand, if you refuse credentialing to a particular physician or a particular practitioner, they're not going to be very happy, and they may sue you for any number of theories because of the potential adverse effects that it may have on that particular practitioner, including a report to the data bank, which becomes a black mark on them. It can adversely affect not only their current practice, but their opportunity to get other employment issues. So it's entirely possible that they may sue you if you don't engage in appropriate credentialing. Well, they may sue you even if you do, but at least you'll be protected. The good news is, at least when it comes to liability to the practitioner, courts usually do not second guess a facility's credentialing decisions so long as that facility followed the standards that are set forth in the bylaws and the statutes, and that decision was based on a legitimate documented needs or reasons. They can be patient care or facility operations reasons, but the reasons should not be arbitrary or capricious, and certainly they can't be motivated for an improper purpose, such as discrimination, anti-competition, anti-competitive, retaliatory, those types of things. So it's both this substantive and procedural standard, right? And as long as you stay within the scope of that procedural standard, you're following the process in your bylaws, and that you are also basing that decision on reasonable, legitimate bases. The courts usually don't second guess what the hospital is doing. The court doesn't want to step in there. They're not physicians. They aren't really qualified to make those determinations. And as long as you're following those processes, in most cases, you are going to be okay. Case in point, a case here in Idaho, where I happen to be. There was a situation where the local hospital, one of the local hospitals, refused to grant privileges to a particular physician because the physician allegedly had engaged in disruptive behavior in the past. That physician obviously was not happy. He ended up suing them, and they went all the way to the Idaho Supreme Court, and the Idaho Supreme Court said, no, hospital, you're fine. You acted within the scope of your authority and appropriately. They held that the bylaws do not constitute a contract. Now, that's not true in some cases. In some states, they've held the medical staff bylaws do constitute a contract between the medical staff members and the hospital. Especially in those states, it's really important that you review your bylaws carefully, and so that you can abide by those and treat them as if it was a contract. If you're not in one of those states, then my advice would be to include language in your bylaws that confirm that it doesn't constitute a contract. Aside from that, the court went on to say, hey, the hospital certainly has to comply with the statutes and the bylaws, but in this particular case, the hospital did give the process that was due under and satisfied the statutory standards, and therefore they dismissed the action by that provider. So let's talk about some of those credentialing standards that set forth either the procedural or the substantive standards, including the United States Constitution. This goes all the way to the top. State statutes, regulations, or case law from your particular state dealing with these situations. The hospital or critical access hospital Medicare conditions of participation, they have specific requirements concerning credentialing. The Healthcare Quality Improvement Act that we'll come back and talk about later, medical staff bylaws, rules and regulations or policies, your practitioner contracts, accreditation standards, maybe others, but generally you need to make sure when you're engaging in your credentialing or peer review activities that you're acting consistent with these applicable standards. Let's get the Constitution out of the way. The bottom line here is that, uh, well, for private hospitals, there's no constitutional issues in there anyway. For even at public hospitals, though, the United States Supreme Court held back in 1927 that there is no physician has a right to practice at a public hospital. Now, once privileges are granted at a public hospital, then some courts have held, some states have held that that may create a property interest in that for that physician, and therefore the public hospital, a government hospital, can't just simply deny their privileges unless you give them some kind of a due process. In addition, no hospitals really can deny privileges for reasons that are prohibited by the Constitution or federal law, including discrimination and things like that. Aside from those, we are really dealing with state statutes, regulations, those types of things. And those involve both substantive standards and procedural standards. The substantive standards are those factors that you may consider that are appropriately to be considered when you're determining privileges or medical staff membership. The procedural standards are the processes you have to go through in making that determination. And you got to satisfy both of those requirements. The substantive standards would be things like, what types of providers are approved by the governing body to have privileges at your facility. They have to be qualified legally and professionally. They have to have sufficient physical and mental capability and so forth. The procedural standards would be things like, okay, well, how do you go through the process, the application, they have an agreement to abide by the bylaws, delineation of privileges, and so forth. Let's focus first on those substantive standards. In general, hey, if you operate a hospital, you have a right, nay, may I say, you have a responsibility to ensure that those persons who are providing services at your facility are qualified to do what you're allowing them to do. Otherwise, it adversely affects patient care, could subject you to liability. And so you have the right to make those determinations. Now, your determinations in most cases generally have to be based on reasonable criteria. What are some of the reasonable criteria? Well, it could be certainly licensure, scope of practice, education, training, experience, physical and mental capability, professional judgment, professional character, including, you don't want an SOB on the staff. Could be professional conduct, capability of the hospital. You can consider, what your facility is able to do and whether or not you can accommodate those particular privilege requests. Effective hospital operations. For example, do you need those services? If not, then you don't necessarily have to allow somebody to practice there. Or exclusive contracts. Maybe you feel like you'd be better with an exclusive, and in most states you can enter into exclusive contracts. Geographic proximity, or any other reasonable legal bases that are relevant to patient care or effective hospital operations, you can generally use those as criteria for your credentialing standards. Well, what would be impermissible criteria? Well, under federal regulations, just simply because the person is a member of a national organization or has board certification does not by itself allow you to credential them. The cops, for example, say that you can't credential them simply by their membership. Generally, you can't rely on credentialing done by others, with a limited exception for proxy. You can rely on credentialing by proxy for certain telehealth providers. We'll talk about that a little bit later. And you can't engage in or rely on impermissible bases, illegal bases, things like discrimination, age, race, sex, disability, religion, antitrust or anti-competitive conduct, union organizing or complaining about working conditions, or whistleblowers or retaliation, political speech. If you're a public hospital, that may be prohibited. So it's kind of like hiring somebody. You can hire them or refuse to hire them for pretty much any legitimate reason, any reason at all, as long as it's not an illegal reason. Well, What about economic or business reasons? For example, can you decide that, hey, we're going to have an exclusive contract and therefore we're only going to give privileges to the member of this particular group that's providing services under this exclusive contract? Or what about closed staff arrangements? Maybe you decide that, hey, we've got all the orthopedists that we need and we don't want to bring on any more orthopedists. Or competitors on the medical staff. Do you have to let everybody come or can you keep off certain competitors? Or utilization or economic credentialing. We're only going to grant privileges to those people who actually use our facility. Can you consider those? Well, most courts, not all, but you'd have to check your state law. Most courts have upheld if there's a legitimate reason and for engaging in that activity, and it's consistent with the bylaws, the organization's bylaws. For example, exclusive contracts, there are legitimate patient care reasons for doing that, or hospital operations reasons, including the need to standardize processes, the need to make sure that you've got adequate coverage and things like that. Similarly, with closed staff arrangements, similar arguments have been made and supported there. On competitors on the medical staff, again, that's a little bit more iffy, but you have to look at your particular state law. Economic credentialing, there are legitimate reasons for doing that. You want to make sure that somebody has a sufficient volume in order to provide care and ensure that maintain their proficiency, and having that utilization, a certain level of utilization at your facility helps you assess that. So there are legitimate reasons here, and you just want to make sure that those are consistent with your state law. The OIG has expressed some fraud and abuse concerns way back when in the OIG Supplemental Compliance Program guidance, but I haven't seen anything recently on that, and I think you're probably okay. When it comes to medical staff, you can have different tiers of medical staff members. So you could have physicians, limited licensed practitioners that have different rights and responsibilities, say, than from allied health professionals. And the medical staff privileges and the rights may differ depending on different types. For example, the rights for admissions or clinical services or voting or medical staff officers or full fair hearing rights. You can generally have different tiers should you choose to do that. When you assign a medical staff member to the medical staff, you're usually going to assign them in a category. Active staff's kind of your basis, but I've seen all different kinds of different medical staff categories depending upon the particular bylaws at issue. An important thing in your bylaws, make sure that you're going to identify for each of those different categories that you have, the qualifications, the associated rights and privileges, their responsibilities, and you'll want to reserve the right of the medical staff or the board to unilaterally modify their medical staff category, hopefully without having to go through any kind of a fair hearing process. All right, here's kind of an emerging issue. It used to be, years ago when I first started practice, that you would have your regular medical staff, and then you'd have a separate subcategory of medical staff for allied health professionals. Things like advanced practice providers, advanced professional providers like APPs, physician assistants, nurse practitioners, and the like. And they would not have the same rights or responsibilities as regular medical staff members. Now, there's a growing trend to actually give those APPs and treat them as if they are, or give them full medical staff membership. The benefit is it promotes unity on the staff. APPs are becoming more important at hospitals and other health facilities. It facilitates APP satisfaction and commitment to the med staff functions if they know they've got a seat at the table and they're not treated as second-class citizens. It may spread out the medical staff responsibilities and ease the burden on physicians. It helps ensure smaller hospitals have a critical mass of medical staff members who are making these decisions, and it may facilitate accreditation. So there's kind of this growing trend to recognize that, hey, we're going to treat them as medical staff members under the bylaws. Now, there are some pushback on that, right? Physicians may not want to share or cede authority with APPs, for example. They may not feel like they want APPs making decisions that are going to affect the physicians. It may complicate bylaws as you try to distinguish the APP's rights and roles. And sometimes it may give APPs rights that are not required or appropriate under a particular statute. For specifically, when it comes to the Healthcare Quality Improvement Act, the Healthcare Quality Improvement Act only provides immunity if you give certain due process rights to physicians. And it doesn't extend that immunity to actions involving APPs. And therefore, you may not want to give the same due process rights in your dealing with APPs unless your state law requires it. Even in those situations, so there are reasons why you may not want to do that. In this growing trend of those situations where you're giving APPs, full medical staff membership, I will still usually put in some kind of caveats or limitations. For example, APPs can only vote within the scope of their licensure. APPs are not eligible to serve as, general medical staff officers, such as the president of the medical staff or the chief of staff, but they can serve as at-large or APP representatives on the MEC. You can do some things like that. So just something to consider. All right. In addition to medical staff membership, when the board appoints a medical staff member or a physician or other practitioner, they've got to identify the privileges that that provider is going to be able to exercise at the particular facility. There's different ways to do that. Sometimes they will do a laundry list that lists like all the things that they can and cannot do. Core privileging is probably more common where in larger facilities, where if you are a member of this particular department, they have certain qualifications or certain things that you're expected to satisfy. Whatever method that you used, ensure that when the board is granting these privileges, that those privileges granted are consistent with the capability of the facility. You don't want to grant privileges if the facility can't satisfy or provide those services or support those services. Obviously ensure the competency of the person who's receiving those privileges. Make sure the privileges granted are within the permissible scope of their practice. For example, APPs they may have to have physician oversight or physician supervision. You want to make sure that the privileges are consistent with any of those requirements. There may be requirements under state or federal law that services have to be provided under the direction or under the supervision of a physician. You want to make sure that your privileges are consistent with that. Make sure that the privileges are going to be consistent with any contract limitations you might have, not only for those particular providers, but for others. For example, if you've got an exclusive contract for radiology services at your facility, you want to be careful about granting privileges for radiology to persons who are not a member of that contract or not part of that contract. All right, now is a good time to veer off and talk a little bit about the Healthcare Quality Improvement Act, a little bit of background about HCQIA. So years ago, the government was concerned about situations where you had bad doctors jumping from place to place. They had a bad outcome or they were kicked off this medical staff, but they would go down the road to another state and get a job with another hospital. And so the government came up with the idea, well, let's create a data bank where you report all the bad actors out there. Well, the problem with that is that the hospitals and those who are involved in peer review, they're concerned about, well, gee whiz, if we report that to you, then that physician is going to turn around and sue us. And we've got this liability and this exposure. And so the government said, okay, well, tell you what we'll do. If you go ahead and you make these reports to us, we will provide immunity to you for making those reports. And that is the basis of HCQIA. So under HCQIA, if a facility or other peer review body gives a physician certain due process rights concerning the peer review actions or professional review actions that they may take against them, and that entity reports certain adverse actions affecting clinical privileges to the National Practitioner Data Bank, then HCQIA grants immunity to the peer review body and participants in that program, that peer review action, from lawsuits arising out of the action. It's very broad immunity. It does not apply to civil rights claims. It only applies to claims for damages, not claims for injunctive relief. And it doesn't apply if the participant seeking immunity gave information that they knew was false. But aside from that, HCQIA gives very broad immunity to those who are going to participate in the program, so long as you give the physician certain due process rights and you report adverse actions to the NPDB. Well, let's talk about when it applies. HCQIA applies to professional review actions against physicians. Physicians means MDs, DOs, or dentists, DDSs or DMDs. Those are the only ones who are covered by HCQIA. It does not apply to APPs or other non-physicians, so you don't get the immunity. You don't have the protection and you don't have the same responsibilities for APPs. It only applies to professional review action involving those physicians. And that professional review action is defined as an action or recommendation of a professional review body which is taken or made in the conduct of professional review activity. And professional review activity is basically to determine whether or not this person's going to have medical staff membership or privileges at your particular facility, or they're going to lose those. And it has to be based, that professional review action to trigger HCQIA, it has to be based on the competence or professional conduct of a physician, which conduct affects or could adversely affect the health or welfare of a patient, and which action adversely affects the physician's clinical privileges. If you are taking professional review action within that definition against a physician, then you're generally going to want to make sure that you satisfy certain due process rights in order to get HCQIA immunity. The due process requirements are set forth in this standard. So for HCQIA immunity, the professional review action that you take against that physician has to satisfy these 4 criteria. Has to be in the reasonable belief that the action furthered quality care, after a reasonable effort to obtain the facts, and after adequate notice and hearing procedures were given to that practitioner or that physician, and the decision has to be taken in the reasonable belief that the action was warranted by the facts. That is the standard to determine whether or not you get HCQIA immunity. And you are presumed to have met that standard unless the physician rebuts it by a preponderance of evidence. So that's very helpful to health entities who are engaging in credentialing activities. Now, in order to get the immunity, you just have to satisfy those standards. But HCQIA goes on to say you're deemed to satisfy these standards if you provide certain levels of due process. Now, the failure to provide that does not mean that you don't get HCQIA immunity. It just means you don't get that safe protection. So it's deemed to satisfy HCQIA standards if the entity gives the notice of the proposed action to the physician, including the reasons for the action, identifies witnesses, gives a right to a hearing at least 30 days after the notice, and you provide a summary of the rights that the physician has to the due process. The physician would have a right to a hearing before either an arbitrator, officer, or panel who is or are not in direct economic competition. The physician has a right to be represented by an attorney, have a record made, call and cross-examine witnesses, present evidence, and present a written statement at the end. The physician has to receive written recommendation with the reasons from the arbitrator, officer, or panel, and the physician has to have the chance to submit or to receive a written decision of the healthcare entity concerning the basis of the decision. So if your due process, the process that you set forth in the bylaws or the like, satisfies these requirements, then you can get HCQIA immunity. Now, you're not required to, there's nothing in HCQIA that requires you to give this due process. It just says if you want HCQIA immunity, then you've got to give the due process. But this is why in your medical staff bylaws and the like, the principal reason why you have these due process requirements in there for physicians is so that you can get the benefit of a HCQIA immunity. Now, note that that immunity only applies to physicians, so it may be that you don't want to give that same level of due process because it's burdensome and expensive to non-physicians because you don't get the benefit of HCQIA immunity in those situations. You should also check state law because state law may require you to give some level of due process, and so you need to be aware of that. But it's generally, you want to make sure that you're, in the case of physicians, that you're providing that due process to get the benefit of the HCQIA immunity. Now, HCQIA generally requires due process, but there is an exception that HCQIA does allow you to impose precautionary or summary suspensions for up to 14 days while you're kind of figuring out what's going on. So if it's a situation where you need to issue a precautionary suspension because, for example, you think that the physician may pose a risk to patients, or they may be interfering with hospital operations or whatever, you can go ahead and impose that for up to 14 days and you don't have to give any due process associated with it. If that summary suspension or precautionary suspension lasts more than 14 days, then to get HCQIA immunity, you have to give the due process that's required under HCQIA. If you have a suspension that's in place for more than 30 days for any reason, then that has to be reported to the National Practitioners Data Bank, like we'll talk about later, so long as that suspension is related to professional competence or conduct that could adversely affect patients. Another case, just to show how powerful HCQIA immunity is. It's a case that I actually had, one of my first ones after I returned to Idaho. This was a situation where a physician sought privileges at a particular facility. Actually, the physician had privileges, but they were provisional, and there was a question about whether or not he was going to advance. The hospital conducted a hearing and ultimately concluded that they were not going to allow this physician to advance to beyond provisional status, and that his privileges would be terminated. The physician was not happy. He ended up suing about everybody associated with the hospital for a claim of about $2 million under a whole bunch of different theories. We brought a motion for summary judgment, and the court dismissed all the claims based on HCQIA because we had followed that due process very carefully. And because of that, we are entitled to HCQIA immunity. Now, HCQIA doesn't apply to due process claims. This was a government hospital, and therefore the physician brought a due process claim. But because we had satisfied the HCQIA standards, we gave him due process, and therefore the court granted summary judgment on that claim also and awarded us $120,000 in attorney's fees. The bottom line here is when it comes to taking action concerning physicians, you're going to want to make sure that you satisfy HCQIA standards. All right. So that's the background, why we've got that process for credentialing and the like. Let's talk about some of the issues when it comes to that credentialing process. You're not required, in most cases, you're not required to comply with the HCQIA standards, those due process requirements, but in most situations, you're going to want to, at least in the case of physicians. And therefore, chances are your process that's set forth in your bylaws or your policies satisfy at least the HCQIA requirements. That process generally includes the following in most cases. There's usually in the credentialing process an initial application phase where the provider submits the application, your medical staff services office or administrations then gathers the information needed, verifies that information, conducts appropriate data searches, then they go ahead and send it on to the medical staff for review. That review in most cases has to be done by the medical staff, usually the active medical staff, who will review the file. They'll take whatever additional information they may need, including interviewing the practitioner or whatever, and then they will make a recommendation to the board. Almost universally, if not universally, the statutes give the ultimate authority to make decisions concerning credentialing to the governing body of the facility. So all the medical staff can do in most situations is simply make a recommendation to the governing body. And it's the governing body who has to make that determination of who's going to get privileges or medical staff membership or what the conditions are associated. So when that medical staff is going to make the recommendation to the board, in most bylaws, that's where it will trigger the hearing right. That if that recommendation is going to constitute adverse action against the physician, it's going to, they're recommending denial or limitations or restrictions or those types of things. That's usually where the hearing process will be triggered, and you would want to comply with the HCQIA standards if you're going to go through that hearing process. Now, the process that you go through, this credentialing process, because HCQIA treats physicians differently than non-physicians, and the immunity only applies to physicians, you may want to actually have a process that varies for non-physicians. You're not required to, but you may. And so a lot of times when I'm drafting the medical staff bylaws, I will have certain requirements for physicians, certain due process requirements in order to satisfy HCQIA. But when it comes to non-physicians, I may have a more expedited process. They may not get the full hearing process. Now that can create PR issues internally. And sometimes we have to negotiate those things, but there are options there that you don't necessarily have to treat everybody the same unless your particular state law requires you to do it. When it comes to that credentialing process, you might want to consider a two-step process. The first step is where you get kind of the objective criteria, the basic qualifications that that applicant has to satisfy. And you can set forth in the bylaws that, hey, you got to satisfy these. And if you don't satisfy these, we're automatically terminate, your application is going to be denied, right? And in that situation, you might have it set up so that in those situations, you don't go through the hearing process, which is cumbersome and time consuming and the like, because what is there going to be a hearing about? If you don't have a license, you don't have a license. And so maybe you want to have this process that allows you to weed out people at the beginning stage without having to go through that hearing process. On the other, assuming that they satisfy that process, then it goes to the medical staff for its review on kind of the subjective factors. The benefit of this process, it allows you to weed out ineligible applicants more quickly. It saves the time and reduces the burden on the medical staff leadership so that they don't have to take a look at all this stuff if the person doesn't even satisfy basic qualifications. And it may avoid the hearing process and NPDB reports if you're making those determinations based on simply because they don't satisfy basic qualifications, because that's usually that's not reportable to the NPDB. But you're going to want to check your state law and look at your bylaws to make sure that it's consistent if that's the way you're going to go. As far as credentialing process, among others, I provided you a sample checklist. I'm not going to go through all of those things. I'm sure you're familiar with a lot of those requirements. I am going to touch base on a couple of issues, though, when you're going through that process. Make sure that you put the burden on the applicant to produce the relevant information. I mean, they're the ones who are applying. It's not your job to chase down all of that information on their behalf. Now, I guess if you really want them to come to your facility, you may be willing to do that. But generally, it's the burden, it's the applicant's burden to establish that they are qualified or satisfy the qualifications that are set forth in your particular bylaws. You should notify the applicant that you don't, until their application is complete, you've got all the records that you need in order to process the application. Then that's when the further processes in your bylaws would take place. Let's talk briefly about the credentialing process, NPDB queries. So in the case of hospitals, if you represent a hospital, the NPDB regulations and HCQIA require that hospitals must query the NPDB, the National Practitioner Data Bank, about a healthcare practitioner. Now note that this querying requirement is broader than just physicians. It applies to any healthcare practitioner. A healthcare practitioner is defined as an individual who is licensed or otherwise authorized by a state to provide healthcare services, or any individual who, without authority, holds himself or herself out to be so licensed or authorized. If you are considering those persons for clinical privileges at your facility, then the hospital has to query the NPDB. You have to do that query at the time the practitioner applies for a position on its medical staff or for clinical privileges, and you've got to query at least every 2 years thereafter for anybody who's on the medical staff. Now, note that the regulation still requires you to do that query every 2 years, even though Joint Commission and CMS has allowed you to do 3-year recredentialing. If you fail to do that query, then there's really not specific monetary penalties, I don't believe, but you are presumed to have knowledge of any information that would have shown up in the NPDB report. So if you put somebody on the medical staff and the NPDB report would show that they were a bad actor and you messed up by putting them on the medical staff, then you may be subject to a negligent credentialing claim. In order to do that query, you guys all know this probably already, you have to become registered with the NPDB. They only allow certain entities to register with them, but if you're registered, then you have to query the NPDB by going to that website. Now, aside from the NPDB requirements, there's also the separate requirement that you need to query the list of excluded individuals and entities. This isn't a HCQIA requirement. It's not an NPDB requirement. This is in order to ensure that you're complying with the federal civil monetary penalties law or the federal exclusion statute. That's the statute that says that, hey, if you're participating in Medicare or Medicaid, then Medicare and Medicaid doesn't pay for any services that were ordered or performed by a person who's been excluded from those healthcare programs. Not only that, but you can't submit a claim for any item or service furnished by an excluded individual, and you cannot even hire a contract with an excluded entity. If you do so, then you have to repay the money that was provided improperly. You can get hit up with civil monetary penalties of about $25,000 per item or service, treble damages, exclusion from Medicare or Medicaid. So the bottom line is you want to make sure that you're not letting excluded persons on your medical staff, or you're not contracting with these excluded individuals to avoid any of those penalties. How do you do that? Well, you check the LEIE query. How often do you have to do that? Well, they update that on, I think it's a monthly basis. If it's on there for any significant period of time, then you're going to be deemed to have known or should have known that this person was excluded, and you could be potentially subject to sanctions. So You should be checking the LEIE when you're looking at contracting or granting medical staff membership or clinical privileges, but you should also do it periodically thereafter. All right, after you've gone through that initial credentialing process, you're going to shift it to the medical staff. The medical staff does its thing where it can review the information that's provided. They have broad discretion in the information that they want to gather to look for, to determine privileging decisions. It may be that they want to interview the person. They may request additional information. They may request some kind of proof of competency. They may, in some certain cases, may want to get some kind of evaluation of their competency. So they go through that process. Then that's when they make the recommendation to the governing board. If that recommendation is to grant it, then it just goes on to the board. If however, they recommend a denial or restriction or limitation or conditions, then that is what usually will trigger the hearing process where the physician has the right to a hearing concerning those determinations. Once it goes to the board can review the recommendation from the medical staff. The board makes the ultimate decision, right? They don't have to go with what the medical staff determines. They can make their own decision. Now, chances are the members of your board are not medical staff members, and so how are they, or they're not clinicians, so how do they know whether or not the recommendation is appropriate? Well, generally, when it comes to the board's review, the board should be really considering whether or not the recommendation is reasonable and supported by the evidence, whether the decision is consistent with the bylaws, both under the substantive standards that are set forth in the bylaws and applicable law, and that the procedure was followed, and that the decision is not arbitrary, capricious, or based on illegal reasons, including anti-competitive conduct or the like. So the board members don't have to be physicians in order to do this, but they need to basically be the check and the balance to make sure that the decision that's coming, the recommendation from the MEC is reasonable and that it's consistent with the bylaws and they followed the right process. That the board may accept the recommendation, they could return it back to the MEC for additional investigation. The board could conduct its own investigation. They could deny, accept, or modify the recommendation as they seem fit because they are the ultimate decider. Depending on the bylaws, if the board makes those additional decisions or changes that adversely affect the provider's privileges, then that may trigger additional hearing or appeal rights. When it comes to this whole credentialing process, be aware of the warning signs, right? If there's something that doesn't smell right, or if there's unexplained gaps, or if there's people have issued concerns, be really careful in those situations. Where there's smoke, there's usually fire. And it's a lot easier to keep a medical staff member or a bad person off the medical staff than it is to take adverse action against them later. You may be a small facility. You may just be trying to find anybody you can that's alive that will provide services at your facility. And so it may be really easy for you to want to overlook these red flags that may come up in the credentialing file, but be really, really careful about that. One is because people, a lot of times these providers don't change. And if they had problems someplace else, they're going to cause problems for you. Two is in most states, you can be liable for, if not by vicarious liability, because this physician's your employee, even if they're just a medical staff member that you're not generally liable for, you can be liable for negligent credential if you credential somebody improperly when they shouldn't have been. So be careful about just deep sixing or ignoring those concerns that may come up along the way. All right, I mentioned before that the general rule is you can't have credentialing by proxy. You can't just rely on proxy credentialing, that because this physician has privileges at this other hospital, we're going to automatically grant him privileges at our hospital. That generally is not allowed under applicable standards. There is a limited exception to that for telemedicine privileges under the hospital and critical access hospital conditions of participation and Joint Commission standards, that they generally allow a hospital to rely on credentialing done by a remote hospital or another entity for certain telemedicine privileges, as long as you satisfy certain criteria that are set forth in the conditions of participation. You got to have a written agreement with that other entity. That other entity has to comply with conditions of participation standards dealing with credentialing. That practitioner has to be privileged at the distant site. The practitioner has to be licensed in the state where the services are provided. The hospital has to review the practitioner's performance and provide the results to that distant site. The bottom line is, if you're going to engage in that credentialing by proxy for telehealth providers, then you need to make sure that you're participating in Medicare, you need to make sure that you satisfy those requirements. Now, even though Medicare allows that, doesn't necessarily mean that your state may allow it. So make sure that that credentialing by proxy is consistent with state laws and also the standards for credentialing, so that you're not hit up with a negligent credentialing claim. The accreditation standards and the government generally allow emergency or temporary privileges. If you really need services or it's an emergency, those types of situations, then they generally will allow you to grant on a limited basis emergency or temporary privileges, but there are certain processes that you have to go through to do that, and it's limited. The Joint Commission, I believe, generally requires that you've got to establish that that practitioner is needed, but there's no time to go through the full process. The privileges are temporarily granted while the formal application is going to be processed. It can be subject to an expedited review, but there still has to be some review process involved to make sure that they're licensed or the like. And it has to have an automatic expiration date, depending upon the nature of it. It has to automatically expire after, for example, 60 days. And you're not supposed to do just kind of these serial 60-day reappointments in those situations. Be really careful about relying on these emergency or temporary privileges, because it could open yourself up to liability if you're improperly credentialing somebody who is not qualified to do what they're doing. So be careful about just relying on that. When we're talking about credentialing, we're not only talking about the initial appointment, but also reappointment. Generally, the standards require that must occur at least every 2 or 3 years. As I mentioned, the COPS and the Joint Commission now allow you to do re-credentialing every 3 years, but your states or your bylaws may not have been updated, or they still may require credentialing every 2 years. So if that's the case and your state doesn't care, then you may want to change your bylaws to allow for re-credentialing every 3 years, but you may want to look at that. The process for re-credentialing is similar to the initial process. Usually has an application, there has to be reviewed by the active staff, and there has to be ultimately a governing body determination. So make sure that you're complying with those requirements. All right, that is correct. The initial rules for credentialing. Let's talk about corrective action. There may be times when you need to take corrective action against a physician or other healthcare provider, and just like the initial appointment process, you need to make sure that you're handling that in an appropriate manner. An initial question for you is, okay, do we want to go through the medical staff process, or if we've got a contract with this physician or other healthcare practitioner, either an employment contract or a contractor relationship, do we want to handle that as an employment matter rather than going through the medical staff? There are pros and cons. I'm generally in favor of handling those as employment actions, because it's usually more efficient. Administration, they know how to handle these types of things. They're experienced. Medical staff members aren't very good and very experienced in handling those situations. So there are benefits to handling it as an employment action. If you take adverse action against them and they terminate their employment, then that probably makes the medical staff process moot in a lot of situations. Now, there's downsides to doing that. If you handle it as an employment action, there is no HCQIA immunity. There's maybe no peer review immunity, although that may depend upon the scope of your statute. The med staff may want to be involved. I've had situations where the med staff doesn't want to handle it as an employment action because they think that they may be on the one that on the receiving end of that at some point. They usually change their mind when they realize how burdensome the med staff process is on them. But it could depend on your contract terms, whether or not your contracts will allow you to take appropriate action just simply based on the employment contract. The other alternative is rather than handling it as an employment matter, to let it go through the med staff process. The benefit is you could get HCQIA immunity and may avoid a breach of contract claim for employment under the employment contract. Again, the cons to that, the downside to that, is that due process is expensive and time concerning. And quite frankly, a lot can go wrong there, usually because medical staff members are not used to doing that, or the medical staff members, they may think, but for the grace of God go I, and sometimes they want to give more deference to the medical staff members. So those are some things to consider. If you are going to have that option, you may want to include certain terms in your contracts or your bylaws that would facilitate your ability to use those different options. So for your employment contracts, for example, you may want to include terms that say you condition the contract on an unrestricted medical staff membership or privileges, that you have robust performance standards or termination provisions in your contracts, including cause and no cause termination provisions. And most importantly, you'll want to include a provision in there that if termination of the contract allows you to automatically, or constitutes an automatic resignation of the privileges without the bylaws hearing. So the provider, by signing the employment contract, waives any due process rights that otherwise might appear in the bylaws. And you'll want to have a provision in your contract that confirms that to the extent there's a conflict between the contract and the bylaws, that the contract provisions apply. Similarly, in the bylaws, you may also want to include additional terms that would be helpful, including terms like confirm that the bylaws do not constitute a contract and don't give rise to contract obligations. Have provisions that state that if you've got a contract provider who's a contract employee or contractor, that the terms of the contract control over the terms of the bylaws. And you can see other terms that you may want to have in your contracts for that. The good news when it comes to corrective action, again, courts usually do not second guess an organization's corrective action as long as that decision, that corrective action, is based on appropriate factors, meaning valid patient care or business reasons, not discrimination, retaliation, unfair competition, or the like, and that decision is not arbitrary and capricious, and that you gave that practitioner you gave them the due process that's required by the contract, bylaws, or other applicable laws. Again, from a legal liability perspective, usually the process becomes more important than the actual decision. If a court's going to look at this, they're primarily going to look at whether or not you followed the right process rather than trying to second guess the court on, or the hospital on the decision. When you're looking about or thinking about corrective action, make sure whatever action you're proposing is consistent with the practitioner's contract, if they are contracted with you, your bylaws, policies, and procedures, state statutes, regulations, and cases, constitutional due process if you're a public entity, and HCQIA if it involves physicians. If you are going to vary from those standards, then the physician can usually always waive that, but you're going to want to secure that waiver in writing. In certain circumstances in your bylaws, you probably want to establish bases for automatic suspension or termination. These are the types of things that, look at, it's just clear. It's just right. There's really no reason for a hearing because, there's no dispute that the person lost their license. If they lost their license, they can't provide the services. So in your bylaws, you may want to have a list of these situations that give rise to automatic suspension or termination of privileges without going through the full fair hearing right. Now, the benefit of that is that it avoids having to go through that full process. The downside is you won't get the benefit of HCQIA immunity. You will have to make sure that you make sure that those decisions are consistent with your obligations under state law. When you're taking corrective action, you can do an informal response. It may just be a collegial discussion, maybe an evaluation, proctoring, things like that. In those situations, you can have kind of a progressive discipline situation. Make sure that what you're doing, again, is consistent with the bylaws, and make sure that you document these informal responses. I just got done with a hearing not long ago where there was a long history of alleged informal responses, but there was very little in the medical record, and that makes it very problematic. So you need to make sure that you're documenting these informal responses, because it can help you defend against a negligent credentialing claim and help you support an action later on. If you are going to go ahead and proceed, make sure that you conduct an appropriate investigation. In the interest of time, I'm not going to go through all of those facts. That investigation will ultimately lead to a recommendation by the investigating body back to the MEC. If the recommendations is The MEC then makes a recommendation that's going to be favorable to the practitioner or adverse to the practitioner. Make sure that that recommendation comes back and is documented in writing, set forth the reasons for the recommendation and the like, so that because you're going to be judged. If you go to a hearing, you're going to be judged by the information that's in there on that recommendation and the investigation that's going to be conducted. You can institute precautionary or summary suspensions. You want to make sure that the process that you've got in the bylaws allow you to do that. Quite often I see those, that the precautionary suspension applies if there's imminent danger to the health of any individual. But that's not the only reason. It may be for significant disruption of healthcare operations. You can put other bases in your bylaws for summary suspensions. It's not mandated any particular one under a Healthcare Quality Improvement Act or the like. In order to get the benefit of the Healthcare Quality Improvement Act, again, if the suspension is less than 14 days, you don't need anything else. If the suspension is going to be more than 14 days, then you do have to put in place some type of due process that generally requires you to, within that 14-day window for the summary suspension, to conduct a preliminary investigation to determine whether or not you're going to initiate formal actions, either a formal investigation or move forward to the hearing process. But that's and you need to take appropriate steps once you hit that 14-day mark, if not before. All right. In the case of the hearing, if you do have to go to a hearing, make sure that you're complying with the applicable bylaws and regulations. Make sure in those situations that if you vary from that, that you get agreement from the practitioner. Make sure that the hearing process that you go through is consistent with HCQIA standards. If you're involving a physician, if it's just other practitioners, make sure it's consistent with the standards. Note that state law, your bylaws may require due process, but the process that's due depends upon the circumstances. Again, you may not have to give the full hearing process that you would give for physicians to other non-physicians. You may want to consider what your bylaws require and what your state law requirements are, and set up different processes depending upon the particular circumstances. All right. Let's say you've gone through that process now and you've got an adverse action. What do you need to do? Well, the NPDB, the National Practitioners Data Bank, and HCQIA require that you report certain types of actions, or certain entities must report certain types of actions to the NPDB, including, for purpose of today, the most relevant one is healthcare entities, including hospitals. If you're taking certain professional review action against a physician's or dentist's privileges, then you got to do this report to the NPDB. You go to that by going to this website, and you can enter the report. If you fail to do that, then for hospitals and healthcare entities, you can lose HCQIA immunity for up to 3 years. That's your penalty. Now, the good news is, though, before that penalty is imposed, the NPD is going to give you notice and a chance to correct it, to do the report. And you, in addition, you may also request a hearing if you think the NPDB is wrong on that. So you have to kind of be a bad actor or make lots of mistakes if you're going to get hit up with that immunity, because you're going to have the chance to correct the situation. But typically you're going to want to make sure that you're reporting when you need to report. If you are a malpractice payer, if you're paying a malpractice settlement, then they have a separate obligation to report on an NPDB. And for those entities, they can actually get hit up with a civil penalty of $27,000 if they fail to do a report. In addition, under the Healthcare Quality Improvement Act and the implementing regulations, the state medical board is required to report entities that fail to report to the medical board. So you may have somebody else narking on you. So let's talk about the reporting requirements. The hospitals and other healthcare entities must report to the NPD, and in addition to reporting the NPDB rules also require that you have to provide a copy of that report to the state medical board of any action against a physician or dentist. So it only applies to a physician or dentist if the action adversely affects clinical privileges for more than 30 days and is based on professional competence or conduct adversely affecting patient care, or it's a voluntary surrender or restriction of physician privileges while the physician is under investigation for incompetence or professional conduct, or in return for not conducting an investigation. So even if you don't take that action, if a physician wants to avoid an NPDB report by simply relinquishing his privileges, if he's doing that to avoid an investigation or while investigation is pending, then that's also going to be reportable. You have to report if a suspension's in place for more than 30 days, even if it's not finalized, even if there hasn't been a final determination, you still have to report with if the suspension's been in place for 30 days. And if your initial report is inaccurate or no longer valid, maybe you've changed the penalty or whatever, you've got to do an appropriate revision or modification. Now, those are the requirements that apply to hospitals and other healthcare entities for reporting physicians or dentists. That's all that are required to report to the NPDB. You're not obligated to, but you may report actions against other practitioners. If you have questions about the reporting obligations, you can go to the NPDB guidebook, and that gives you lots of directions concerning when you must report. I get the question a lot. Well, it's an investigation is when investigation's triggered. If the physician resigns his privileges after an investigation's triggered, then you have an obligation to report. What constitutes an investigation that's going to trigger that under the NPDB? A lot of times people simply try to rely on how that's defined in the bylaws. The prior version of the NPDB guidelines, that was in there, that they deferred to how it was defined in the bylaws, but that's not the case anymore under the most recent NPDB guidelines. You really look at the substance. So it's not controlled by just simply what you say. In general, an investigation is triggered if it's focused on a particular practitioner, it concerns the professional competence or professional conduct of the practitioner, and it's intended as a precursor to some other professional review action, then it's probably going to be an investigation that triggers potential NPDB reporting. Routine or general review of cases, not an investigation if it's not targeted, if it's just something that you do for everybody. Routine review of a particular practitioner is also not an investigation under those circumstances. As far as the timing, you've got to report within 30 days following the action to be reported. Generally, that means after the peer review activity becomes final, after you've gone through the appeal process. But in the case of a suspension, it's once you hit that 30-day mark, then you need to go ahead and do the report. If you discover the errors in the report, then you've got to send the correction to NPDB as soon as possible. If you revise an action originally reported, then you've got to do the revision within 30 days. You do those revisions, the process for the initial report, the corrections, the revisions, or if you need to void a report, then you go to the website and it'll tell you how to go ahead and do that. If you do report to the NPDB, then generally you have immunity for making those reports so long as it's made in good faith and you don't have actual knowledge of the falsity of the information contained in the report. If you do report improperly, then you can be liable, and there is at least one case out there where somebody's been held liable. So be careful in how you make that report. Make sure that the information you include is accurate. I think generally less is more when it comes to making those reports. NPD reports are confidential. You can't disclose those, and they can only be used for permissible purposes. If you violate the confidentiality requirements, it's a penalty of up to $28,000 per violation. Those are the NPDB requirements. You have to report to the NPDB, also have to give a copy of that to the state licensing board, the state medical board. There may be other state requirements that require you to do reporting, so make sure that you're aware of your state laws when it comes to those reporting, and they may not be the same. You may have obligations to report, for example, a termination of employment to the state, even though it's not required to be reported under the NPDB. All right, a quick word about peer review privilege and immunity, an important factor when it comes to credentialing. You need to make sure that you're preserving any peer review privilege that you may have under state law. There's usually two aspects to the peer review privilege. One is the privilege that protects the confidentiality of the information, so it can't be used under malpractice or other cases down the road. The other is they will usually provide immunity to those who participate in the peer review action. So if they're sued for what they do, that they have immunity. You want to make sure you understand the rules in your particular state so that you can act to preserve that peer review entity, that peer review privilege. That usually means making sure that you designate your credentialing and other entities who are performing those services on your behalf as a peer review entity under the applicable state law. You conduct peer review activities, which includes credentialing, corrective action, everything like that, under the scope of those peer review committees so that you maintain the peer review privilege. Make sure that you maintain the peer review privilege as to applicable documents, including, it's helpful if you stamp them, protected by peer review. You don't leave them out there floating around. You collect those and make sure that those are secured. Even though the peer review privilege is out there, don't assume that these records are going to be privileged or protected in all cases. It may be that in federal courts, the peer review privilege may not apply. It may be along the way that you may want to actually bring those up to defend yourself. So even though the records may be privileged, you're still going to want to make sure that they're appropriate. And whatever you put in those records, make sure that if they are read by a third party down the road, that it's appropriate and you're not going to be embarrassed. Just in final, I want to mention some protections for medical staff members and leadership when it comes to engaging in these credentialing activities. The first is just the general standard that courts defer to what you do as long as your action is taken consistent with the bylaws, it's documented by legitimate reasons, and you followed the process. Then in those situations, generally you have a deference from the court. In addition, because the government wants you engaged in credentialing activities, there's a whole bunch of protections that apply, statutory protections. We talked about HCQIA already, but there could be state peer review statutes. There's the Federal Volunteer Protection Act, state protections for nonprofit officers and directors, the Local Government Antitrust Act, state tort claims acts that may apply to government entities. So be aware of those protections. In addition, it's a good idea to get as part of your applications process to get waivers or releases from the providers, that they waive and release you from any liability arising out of the credentialing process. Those may or may not be enforceable, but you're better off having them signed if you've got it. I've given you in the materials I provided a sample agreement that you might consider. In addition to that, if you're serving on a medical staff leadership position or as a director or officer, you may want to see about getting indemnification agreements from the organization to make sure that you're protected. You may also want to talk to them about directors and officers insurance, which may or may not apply, but it's another thing to consider. All right, I know I went through a whole lot. The PowerPoint presentations have a lot more content in them. Hopefully you can access those and it may answer questions. If you have additional questions, feel free to give me a call and I'll try to respond offline. Other than that, thank you very much for your participation. I think in a couple of weeks, Jay Devoy will be back talking about discrimination laws.